Good morning. My name is Dorian Peters, and I am the 2021 Contra Costa County Bar Association Board President. On behalf of the Contra Costa County Bar Association, I want to thank you for attending the 27th Annual MCLE Spectacular. I hope you have enjoyed this year's presentations. This session, Developing the Theory of Your Case, is presented by the CCBA's Litigation and Barrister sections, and is the first in our 2022 Basic Trial Skills series. For questions about attendance certificates, evaluation forms, and materials, or assistance with any technical difficulties, please head to the FAQ tab on the event homepage. As a reminder, our sponsors are a very important part of our CCCBA community. They make it possible for us to produce events like this. Please support us by supporting them and take time during the spectacular to visit their online booths. Don't forget, while this program is pre-recorded, the speaker is available live in the chat to answer your questions during the presentation. They will also be available in the live Q&A immediately following the presentation. At this time, I would like to pass the program to Adam Carlson from the Litigation Section Board, who will introduce today's speaker.
Thank you, Dorian. Hello, everyone. My name is Adam Carlson. I'm one of the managing partners at Casper, Meadows, Schwartz & Cook, a personal injury firm based in Walnut Creek, and I'm on the board of the Litigation Section, which has organized this presentation. Before introducing our speaker, I wanted to make a quick announcement. The litigation section is co-sponsoring with the barrister section what we are calling the Trial Basics series, which is being kicked off by this presentation today. The series is aimed at teaching essential skills to take a civil litigation matter from initial pleading all the way through trial. The series will be one CLE session per month on the second Tuesday of the month, starting in January. On January 11th, we have discovery and depositions. On February 8th, framing issues and drafting pleadings. On March 8th, jury selection, opening statements, and closing statements. On April 12th, direct and cross-examination and objections. And lastly, on May 10th, effective uses of ADR. If you are attending today's presentation on the theory of the case, then the rest of the programs in this series are likely of interest to you. So look out for announcements about those programs in the future. I'd like to introduce our speaker today, Anthony Matriciani, who works at the firm Hartog, Bear & Hand. Anthony represents beneficiaries, heirs, fiduciaries, and interested persons in trust litigation, will contest, financial elder abuse litigation, and conservatorship proceedings. Prior to focusing his practice on trust and estate litigation, Anthony represented clients in general civil litigation and was a deputy public defender and private criminal defense attorney who defended clients in trial court proceedings ranging from misdemeanors to special circumstance murder. The presentation today will explain the necessity of a theory of the case, how to create and implement a theory of the case, and using narratives and themes to further the theory of the case. I'm sure you all enjoy the presentation today and learn more about this important topic. So now I'll pass it over to Anthony.
Thank you, Adam. So I'm going to discuss developing a theory of the case. I'm going to define what a theory of the case is, explain how it functions in your preparation and through presentation at trial. I'm going to use themes with your theory of the case and your trial presentation. And I'm going to use the process and practice of cross-examination as an example of how to develop and establish your theory of the case. Generally, a theory is a supposition or a system of ideas intended to explain something. It's especially one based on general principles independent of the thing to be explained. Perhaps a more relevant definition for trial purposes, a theory idea used to account for a situation or justify a course of action. Think about accounting for the facts of the case and justifying the client's course of action. A theory of the case is a cogent statement of an advocate's position that justifies the verdict sought. Everything I talk about, probably in some form, has been lectured on by Larry Posner and Roger Dodd. Their book, Cross-Examination, Science and Techniques, is the book on cross-examination, but it discusses a lot more than that, like theory of the case and opening and closing, and I encourage you to read it. By cogent, we mean clear, logical, and convincing. But a theory of the case is not just based on reason, it's also based on emotion. This is part of a quote, of an extended quote that I'm going to read to you. I want you to think about how this relates to what we do as litigators and as trial lawyers, how we put pieces together and how we orchestrate narratives. One of my former students developed a useful illustration of the functions of theory with reference to music. She wrote that the elements of music theory include notes, keys, intervals, chords, and time. The musician uses this knowledge to select notes and put them together in chords with different rhythms to explore musical ideas, including harmonies, dissonance, and improvisations. Yet music theory is not the music. The theory is a way to describe the music and gain an understanding of how it can be performed. It explains why some combinations of notes and chords seem to work well while others do not, and gives the music student ideas for writing new songs. Your theory of the case is not the facts, it's not the evidence, but it explains the evidence. It explains the relationship among the facts. Theory matters because ideally, it's the basis for all of the choices you make in a case and all the actions you perform. From the very beginning, before filing a complaint or a petition, before responding to a complaint or a petition, all the way through the appellate process. A theory helps reveal the most important issues and facts about the situation. A theory reveals that which is necessary and unnecessary. It also explains why that information is necessary or unnecessary. Within the context of a trial or a lawsuit, it explains why something is relevant and irrelevant. Theory enables one to explain a phenomenon and, if necessary, decision-making processes. Your theory of the case not only will have to explain what happened and why, but it may also need to explain your client's decision-making process to justify his or her conduct. Lacking a theory of the case, the phases of trial are but academic exercise of the right to trial without a unifying purpose. You cannot prepare for trial efficiently or effectively without developing a theory of the case. You will get lost in the details and you will lose the fact finder along the way. A theory of the case creates a path to the lawyer's trial goal and creates a framework for unifying favorable, unfavorable, and neutral facts into a persuasive presentation. A theory of the case can inspire creativity. Limiting oneself to a particular theory can force one to become more creative even within a strict framework. A good theory explains consonance and dissonance, just like in Western musical theory. A good theory of the case is going to explain consistencies or patterns of consonants. It's going to resolve tensions in the evidence. It will resolve conflict. A good theory of the case demonstrates how seemingly conflicting evidence is actually consistent with a party's narrative. Now we're going to borrow from social science some characteristics of a good theory. A good theory for practice should be, first and foremost, coherent. It has to be internally consistent. If you can't keep track of your theory, you can't expect a fact finder who's learning of the facts for the very first time often. If it's a judge, we'll talk about that a little bit later. If it's a judge, you've already told them your theory of the case at some point. In a motion, in a trial brief, you've done that. Before a jury, this is the first time they're going to hear your theory of the case. It has to be internally consistent, or it's not going to be believable. People are not going to be able to follow it. A good theory is useful with the practitioner's current clients. This also applies to our work as litigators and trial lawyers. Every case is idiosyncratic. Every client is idiosyncratic. I make the distinction between client and case specific because if you were to read a transcript or a police report and come up with a theory of the case without meeting your client, once you meet your client, you may need to change your theory of the case, or you may need to refine it based on how your client presents, your client's physical stature, your client's health, all kinds of factors. So the theory of the case must not only fit the facts of the case, it must fit the client. A good theory is comprehensive. It accommodates all facts beyond change. We're going to talk later about facts beyond change. Parsimonious, uncomplicated. Ideally, you can communicate your theory of the case in a sentence or a phrase, sometimes perhaps even a word. A good theory is testable. It's able to withstand scrutiny. It stands up to alternative theories. It stands up to your opponent's theory of the case. It doesn't necessarily have to knock out that theory of the case, but it has to provide you with space to persuade the fact finder. It has to provide you with something you can offer them so that they have something to think about. They don't just buy what the other side is selling. A lawyer's ability to be effective is due in part to having confidence in whatever theory he or she uses. Just being confident and not having a theory, in my experience, will not produce a successful result. You have to have faith in your theory of the case. If you don't, then you need to develop another theory of the case. Create a good theory of the case and stick to it. Don't change during trial. Now, there are occasions where some evidence is revealed and maybe you do change your theory of the case. That does happen on occasion. Sometimes you're taking over a case from someone else, and the theory they were operating on just didn't work with the facts. So you have to create a new theory of the case. But generally, if you have a good theory, stick to it, right? Express the notion that the truth remains stable. It doesn't change. And the theory you're communicating to the fact finder is the truth. It reveals the truth. And that's not going to change. Develop a theory of the case as soon as possible. As soon as you start learning facts about the case, you should be thinking of a theoretical framework. You should be thinking of patterns of evidence. As a public defender, we would see these patterns all the time. We'd see them in drug cases, in domestic violence cases, in sexual assault cases. We would see a lot of patterns. And so it would be easy over time to read a police report and start piecing together the theory of the defense. A theory of the case can be developed before all the facts are known because you're not finalizing your theory, and your theory is going to be adaptable. Even though it needs to express clearly your position, it will have a little room in it for you to be flexible. And at the beginning of your case, it's a lot like brainstorming. You can have multiple theories and see how the facts work with those theories. When I was a public defender, we had this practice called I like to think of as the closing argument exercise. As soon as we finished reading the police report, we would create a closing argument. And that was how we got ourselves thinking about the theory of the case. And then we would get another piece of information, like, for instance, the client interview. And we'd go back to that closing argument. And that was a way to force ourselves to think about the theory of the case, to think about putting the facts together in a persuasive manner. The theory of the case should evoke a relatable experience. I think very few people understand what a fiduciary duty is, let alone a breach of a fiduciary duty. So one way to explain a breach of fiduciary duty to a layperson is to use a relatable experience. So imagine you are representing a trustee, or you're representing someone who's accused of breaching a fiduciary duty. And your theory of the case, or one of your themes, is Monday morning quarterback. So let's say this trustee is accused of intentionally failing to liquidate an investment that was failing. The defense is that the failure of the investment is obvious only in hindsight. Only if you're a Monday morning quarterback can you fairly say that this person made a mistake. So in voir dire, you might ask people, have you ever been second guessed? Right? Have you ever been Monday morning quarterbacked? A lot of people should be able to relate to that experience. So you're going to use a common, relatable experience to refresh the fact finder's memory of an episode in which he or she did the best they could with the information available, but through no fault of their own, made an erroneous decision. And through that process, the lawyer reminds the fact finder that he or she suffered some type of unjustified criticism by people who did not have to make the decision on the spot. And hopefully, having the person remember that decision, remember that experience, will emotionally resonate, and they'll start to remember the emotions and the emotional aspect of that experience, and begin to align themselves with your theory of the case, and to align themselves emotionally with what your client was experiencing during that event. A lawyer should strive to create a dominant emotion for the theory of the case. Right? There may be several emotions that come out during a trial. One witness, the theme of that witness might be guilt. Right? Another witness might be betrayal. But you should have one dominant overall emotional theme. A theory that is relatable can set the emotional tenor for a trial. So that theory involving the Monday morning quarterback, that idea of that feeling of or notion of unjustified criticism, that can set the tenor for the entire trial. Now, establishing the emotional tenor is important because the vast majority of decisions are based on emotion, not reason. Some of you may disagree with me on that. I always think about this the following way. How many people do you know who've been married, made that decision based on reason? Emotion becomes fact. And this is one of our goals. When the fact finder experiences the appropriate emotional response, and that could be anything, right, based on what your theory is, betrayal, anger, unfairness. It could be joy, commitment, faithfulness. When the fact finder experiences that emotional response, then he or she is making a determination that the fact of the emotional aspect of the case is valid. So we're not just trying to persuade the fact finder that the facts are valid, but the emotional aspect of the case, the way the client felt, which helps explain the client's conduct, the way the client felt, that emotional experience for the client was valid. Thus, the client's emotional response was appropriate, and the client's conduct was appropriate. Once you create emotional resonance with the fact finder will be able to perceive everything from your client's perspective. The theory of the case presents the factual goal, right? It's where you want to end up. It's the explanation for how you get there, why you end up in that place. It's necessary to create a strategy designed to advance the theory of the case. So the theory of the case is necessary to create a strategy designed to advance it. An opponent with a theory but no strategy is tactically inept, often introducing evidence that is unnecessary and obscures the theory or fails to support the theory. Now, the trial strategy consists of the techniques and methods used to present, develop, and promote the theory of the case. The opponent without a strategy tends to attack everything without considering its salience or context and fails to present a cohesive narrative. A theory of the case unifies every aspect of trial preparation and trial. It is the arc of your case strategy. Again, it determines that which is necessary and that which may be disregarded. Just because something is relevant doesn't mean it should be a part of your theory of the case or a part of your trial presentation. Developing a theory of the case, it's often very simple. It's not complex. It doesn't have to be a complex process. I defended myself. Depending on the facts, self-defense might be a great theory of the case. And that's all you have to do to express it. Nothing fancy. A trustee who sells trust property to his friend at a discount. Okay? That's your theory of the case. He sold the property to his friend at a discount. He violated the fiduciary duty of loyalty. The company rushed the product to market before completing safety studies. Right? That's why my client was injured by this product. They didn't care enough to be careful. I was never trained to remove the component before accessing the panel. This might be a personal injury claim or workers' comp claim. He stole from Peter to pay Paul. When I was growing up, I heard this saying all the time. I don't know if it's as popular nowadays, but it's been told to me by so many people. I've heard it so many times. As soon as I hear it, I know exactly what the person is talking about. If a lawyer stands up in an opening statement and says something like this, I know what that case is about immediately. Over time, the theory can be refined and restated, and it should be. As you're acquiring more information, you're conducting discovery, you're getting a sense of the witnesses, the types of evidence, then you're going to refine and restate your theory. Here's an example of a theory of the case. When Gerald was standing in the doorway to Freda's home, unsteady on his feet, reeking of beer, Freda knew he had come to make good on his promise to kill her. And if she were to survive, she'd have to fight for her life. Now, you might have started out with the theory of self-defense. Then you acquired some facts, right? You acquired some information about Gerald, about the condition he was in that evening, about things he had said to Freda before. And so you refine your theory, you restate it. Kenneth, Patty's only fiscally unsuccessful child, resented his sibling's success and felt entitled to his mother's wealth, so he stole millions from her as her health declined. Again, maybe you start out with knowledge that Kenneth was embezzling money, that he was transferring money from his mom's accounts to his accounts. Then you start to learn about the family dynamic. You start to learn about Kenneth's history, the family's history, the relationship among the siblings, and you refine and restate and further develop your theory. Aaron accused Sam of burglarizing his apartment because he thought she had stolen his drugs. The manufacturer knew its all-terrain vehicle was prone to instability and rolling over, but thought it would be cheaper to fight lawsuits than fix its product. He stole from Peter to pay Paul. A simple, commonly used statement can be perfect. So even though these theories I've presented are a little more complex, they put some of the facts you've acquired about the case into the theory. Sometimes something as simple as he stole from Peter to pay Paul is perfect. Praxis. Praxis is practice as defined from theory. It's the practical application of theory. And we're going to discuss a bit how to apply theory, how to apply these principles to create and develop a theory of the case. The first thing you need to do is determine all facts beyond change. A fact beyond change is a fact that will be believed to be true and relevant despite any effort to dispute it. I'm going to read that again because it's extremely important. A fact beyond change is a fact that will be believed to be true and relevant despite any effort to dispute it. If you have a murder case and there's a dead body, that dead body is the fact beyond change. How that body ended up dead may not be a fact beyond change. All right, that's probably what the trial's about. But you've got a body. You're not going to convince anyone that body doesn't exist. In other words, facts beyond change are facts about a dispute that no matter what you do, you cannot change them. However, sometimes sometimes you can eliminate facts beyond change. And I'll talk a little bit about that later. The theory of the case must incorporate every single fact beyond change, or at least be neutral to them. In other words, you have to use the fact beyond change in a favorable way in your case, or you acknowledge it and fit it into your theory and neutralize it. Here's a visual to help you think about facts beyond change. You have favorable facts and you have unfavorable facts in your case. The area where the favorable and the unfavorable circles overlap, that's going to think of that as the facts beyond change. Some of the facts beyond change in a case are going to be favorable and some are going to be unfavorable. But regardless, you're going to have to account for them and accommodate them in your theory of the case. A successful theory of the case never contradicts a fact beyond change. If you have created a theory of the case that contradicts a fact you cannot disprove, your theory fails. And unless some miracle happens, you're not going to achieve your factual goal. You're not going to get the verdict that your client wants. Attempting to disprove a fact beyond change is like asking someone to believe in the impossible rather than accept the known truth. However, motions to exclude evidence can change or eliminate facts beyond change. Motions for summary adjudication or demurring to a cause of action. There are ways to eliminate facts beyond change, even though it's impossible to change them. The reason it's so important to understand that a fact beyond change is one that you cannot convince anyone is different than it is because facts beyond change create limitations, often severe limitations on what evidence you can present, on what you can argue. So make certain that it is impossible to persuade a fact finder that the fact does not exist. Not that long ago, I had a case in which I was reviewing medical records. In 2007, there was a diagnosis of dementia of the decedent. And further reviewing the medical records, I found in 2010, there was a diagnosis of the decedent of cognitive impairment. So when I first saw the diagnosis in 2007, I had concern that the decedent having dementia in 2007 would be a fact beyond change. But then this diagnosis of cognitive impairment came subsequently. The progression of the disease of dementia does not go from dementia to cognitive impairment. It progresses from cognitive impairment to dementia. So this diagnosis in 2010 meant that the diagnosis of the decedent having dementia in 2007, while the diagnosis was a fact beyond change, I couldn't change the fact that someone had diagnosed the decedent in 2007 with dementia. The fact as to whether the decedent had dementia in 2007 was not a fact beyond change, because now we have a 2010 diagnosis that casts doubt on that 2007 diagnosis. So make sure that when you determine something is a fact beyond change, it is impossible to persuade a fact finder that it doesn't exist. Some examples of facts beyond change, and of course, this is all circumstance dependent. In contract litigation, the contract at issue, assuming the dispute, in the dispute, a party is not alleging that there was no contract. A paper trail demonstrating the transfer of funds from the decedent's account to the client's account. Unless you have evidence of some elaborate breach of the financial institution's computer systems and records that resulted in funds being transferred among several accounts, I don't think you're going to be able to convince anyone that that transfer didn't occur. So your theory of the case is going to have to accommodate it. And it could be a very simple explanation. It may not be that your client was embezzling or stealing. Maybe your client had paid a $10,000 medical bill of his client and of his mother. And the mother said, oh, just take the money out of my account and reimburse yourself. Either way, you've got to somehow account for this transfer. Blood analysis indicating that the decedent was not receiving her medications. And perhaps that's important because as a result, maybe someone is arguing that she wasn't as coherent as she should have been. Maybe she lacked capacity. Maybe she was fatigued. Maybe she was weary. And all those things contributed to her being subject to undue influence. I represented a client who was being prosecuted for elder abuse. One of the facts beyond change was that his mother had some awful bed sores. My client lived in an apartment. His mother stayed in one of the bedrooms. She was bedridden. She had a very poor quality of life. She spent the vast majority of her time sleeping. And it was discovered that she had these awful bed sores. There was a criminal prosecution. The mother was taken from the apartment and transported to a hospital. She was placed in the intensive care unit. She was given around-the-clock care. Nothing the physicians, nurses, and hospital could do alleviated the bed sores. And not only did those bed sores remain, but new bed sores emerged. So the prosecution was casting our client as neglectful, abusive of his mother. And those bed sores that she had when he was arrested, it's a fact beyond change. But it's also a fact beyond change that the hospital, with its well-trained staff, with its round-the-clock care, with all the medication that the mother was given, could not alleviate those bed sores, and in fact could not prevent new bed sores from emerging. And so if they couldn't do it, then how could someone expect my client, who's a layperson caring for his mother, to do it? So that's an example of how you've got some facts beyond change that you can be neutral to. For instance, there's bed sores that were present when my client was arrested. You create a theory that is neutral to that fact beyond change. And the theory is not even a medical facility with highly trained staff, round-the-clock care could have prevented this, right? These were going to happen no matter what because of her declining health. So you create a theory that's neutral to that fact, and then you use some other fact beyond changes facts beyond change, as favorable facts. The fact that nothing the hospital could do could prevent additional bed sores. Incorporating facts beyond change into a theory of the case is always necessary. Again, your theory of the case always has to accommodate facts beyond change. And the example I gave about the bed sores is one example of incorporating facts beyond change. Here's one based on a homicide case. Coroner's report concludes there are 6 bullet wounds to the deceased. Every bullet wound is contact or close contact. There's stippling, which is a pattern of bruising that appears on the skin when someone is shot at very close range. Defendant's statement to police is that the deceased attacked him, knocked him down, and was on top of him when the defendant fired upward at the deceased. So you have a self-defense theory of the case. The defendant's statement incorporates facts into the theory. He was knocked down. The attacker was on top of him. That explains the stippling, the close contact when the gun was fired. And if there are issues concerning the trajectory of the shots, then the defendant fired upward at the deceased. That can account for any evidence concerning the angle and trajectory of the wounds. So the facts beyond change are consistent with a self-defense theory of the case. And this case may sound familiar. Generally, these are the facts of the George Zimmerman trial. Let's talk about transforming a theory into a theme. A theme is an idea that recurs in or pervades a narrative or work of art. And you are going to create ideas that recur throughout your case, that occur throughout your narrative, throughout the evidence that you present, throughout your motions in limine, throughout your motions to compel evidence. Motions to compel discovery. Why do you want to use a theme or more than one theme? A theme can simplify the theory of the case. So if you remember, some of those theories of the case were a couple sentences long. A theme can condense everything, can make it simpler. Converting the theory of the case into one or more themes can refine the theory by extracting its essence and expressing it in a word or brief refrain that expresses the essential information of the theory. So it can be kind of like think of it maybe as a catchphrase or a refrain in a song or in an instrumental piece. You keep coming back to it, right? The work of art keeps coming back to it. Think about a novel or a short story or a movie, right? Sometimes a movie will create themes with the setting. Okay? You can create themes all kinds of way with testimonial evidence, right? You can also do it with demonstrative evidence. You can do it with images. I represented a client who was being prosecuted for marijuana cultivation, transportation, and distribution. we had a preliminary examination, and at the preliminary examination, an expert testified. The expert was a California Highway Patrol officer, and he was testifying as to his expertise concerning cultivation and sale of drugs, and specifically of marijuana. There were very few favorable facts I could elicit from the officer based on what he observed. There just wasn't much good he had to say about the situation. So I decided that instead of trying to struggle and elicit information from the officer that I didn't think I was going to be able to elicit, I was going to express one of my themes of the case through the witness. So what I did was I asked the officer a lot of questions that were relevant, but I knew he didn't know the answer to. So during my cross-examination, the officer frequently said, "I don't know." And at points of the cross-examination, that was all he said, 5 or 6 times in a row. "I don't know. I don't know. I don't know." So what I did was I tied that in to my theory of the case and my themes. And one of my themes was that the officer would not have concluded that my client had committed a crime and would not have arrested him had he known all the facts. If the officer had known all the facts, we wouldn't be here today. He would have realized that my client's conduct was lawful, was innocent. After that preliminary hearing, I came back in the afternoon for the court's afternoon calendar, and I was speaking to the courtroom clerk. And the courtroom clerk told me that her sister and brother-in-law had been sitting in the audience during my cross-examination, and that during lunch, she spoke with them, and they were very impressed with that section of the cross-examination. This was a multi-defendant prosecution, so there were 2 or 3 other lawyers who had cross-examined the officer, but they were especially impressed with this cross-examination, and what they kept focusing on was that the officer didn't know anything. So I used that witness, even though I couldn't get good facts out of the witness, I used the witness to develop and to further the theory of the case, the theme of the case. All right, how do we transform theory into theme? Here's an example. Jessica lied about Jason hitting her because she felt angry and betrayed. She found out that Jason came back from duty in Afghanistan 3 days earlier than he said. Instead of coming home, he spent 3 nights with Jessica's best friend, Marlene. This is actually very similar to a fact pattern that I had when I was a public defender. Except instead of Jessica lying about Jason hitting her, the alleged victim in that case had lied about my client strangling her. So this theory of the case becomes a woman scorned. So you've reduced 3 sentences to 3 words. And my bet is that all of you, when I say those 3 words, all of you know what it is my client's defense is going to be, what kind of evidence my client is going to present, and you're going to start thinking about who that alleged victim is. With different facts, this could easily be the jealous husband. All right, let's transform another theory into a theme. Social cultural processes of the United States curtail liberty and justice for non-whites and create and perpetuate disregard for the value of their lives while simultaneously elevating the value of white lives. That's our theory, right? That's kind of akin to or part of critical race theory. Black Lives Matter. The statement Black Lives Matter expresses a history of systemic disparate treatment. It recognizes the intrinsic value of non-whites, and it demands equal treatment. So we took that somewhat awkward socio-cultural processes statement, and we've reduced it to Black Lives Matter. Easy to remember, easy to express. Use every single phase of litigation, every single phase of litigation and trial to advance the theory of the case. This may seem obvious, but I have seen evidence that people fail to do this. Develop your theory of the case. Have a really good idea of your theory of the case before you draft a complaint or petition, before you respond, file an answer, draft a response. Because if you don't have your theory of the case nailed down, and again, you can refine your theory as time goes on, but you've got to have the basic framework there. And if you don't have that in place, if you don't know what your theory of the case looks like, if you don't know what this house you're building looks like, or is going to look like, then you're going to state things in a complaint or a petition, in an answer or response, that don't fit, that don't further your theory of the case, that don't support your claim, that don't support your defense. Or you might say too much, and it might come back to haunt you. It might come back to haunt you when your client is deposed. It might come back to haunt you when you have to draft discovery or respond to discovery. It might come back to haunt you when a witness is testifying at trial. Pre-trial motions. These are a wonderful vehicle for advancing your theory of the case. Discovery motions. A lot of attorneys write pretty simple, stick to the facts discovery motions. I demanded discovery. They didn't respond. We met and conferred. I still didn't get a response. Here's a discovery request. Here's why it's relevant. Well, the fact that you're arguing over the relevance of discovery requests provides you with the perfect opportunity to explain and point out the bigger picture of the case, your theory of the case. Why is this request relevant? Well, it's relevant to my theory of the case. Here's my theory of the case, right? And if you cannot explain how your discovery request is relevant to your theory of the case that you're going to advance at trial, if you can't do that mentally, then it's highly likely, almost certain, that you shouldn't be asking that, you shouldn't be making that discovery request. Because if the information you acquire from that request doesn't advance your theory of the case, what's the point of you doing it? Spoke about this a little bit earlier, excluding evidence, right? You can eliminate facts beyond change by excluding evidence. And you can also advance your theory of the case by excluding evidence. Your opponent may want to bring in all this evidence of how awful your client is. And your client did this and your client did that. Well, you know what? Maybe 90% of that stuff isn't even relevant. So get rid of it. Get rid of it. Clean up what can be offered in the trial so that you have a clear path for advancing your theory of the case. In the criminal defense context, if you're fortunate enough, depending on the circumstances, because sometimes you want your client's statement to come in, but let's say your client makes some awful admissions and you're fortunate enough to exclude those, right? That's going to create that's going to enable you to create a much different theory of the case if you can exclude those admissions. So when you're doing motions to exclude evidence, when you're doing your trial brief, exclude the theory, express the theory of your case to the judge, and just do it as early and often as possible. At trial, do it in your opening statement. Do it in your closing argument. Do it all the time. Often a theory of the case can be adapted for use as an opening line in an opening statement. Use thematic phrases consistent with the theory of the case. Use them throughout the opening. Use them throughout the closing. Remind people the officer didn't know. He didn't have all the facts. You need the facts to understand what happened. Use direct examination and cross-examination. Every question you ask in a direct examination or a cross-examination should further the theory of the case. Every single one. If it doesn't serve the purpose of furthering the theory, then you shouldn't ask the question. Now, I don't mean by this that if the question doesn't elicit a fact supporting your theory, that asking the question doesn't support the theory. Sometimes you need to ask questions of a witness to lay a foundation, right? You have to satisfy the rules of evidence. Sometimes you ask a question of a witness that has a strategic purpose, but that strategy is advancing your theory of the case, even though the fact you may acquire from asking that strategic question doesn't necessarily advance your theory. The theory of the case methodically and in easily digestible portions. I think a very good example of how to do this is through cross-examination, not just the practice of cross-examination. So not just when you're actually performing the cross-examination, when you're asking a person questions, but the process of creating your cross-examination, of thinking through how you're going to do it. Not just which questions you're going to ask, but how you're going to ask those questions and which witnesses you're going to ask those questions of. You may be able to question 7 different witnesses on the same issue, but you may only want to use 1 witness or 2 witnesses for that issue. Cross-examination is a critical opportunity to advance a theory of the case. You are not cross-examining because you have the right to do so as a lawyer. You're doing it because it's necessary. This ties back in to the theory of the case, right? Everything you do should advance the theory of the case. If it doesn't, if it's not necessary, don't do it. The lawyer cross-examines for the sole purpose of advancing his or her theory of the case. Cross-examination is an excellent opportunity to establish facts that assist in supporting the theory of the case. deciding to cross-examine, it's important. I think a lot of people just assume, okay, the other side's going to put on a witness, so I'll cross-examine the witness. But I want you to take a moment and think to yourself, do I need to cross-examine this witness? Because remember, if we're doing everything in accordance with our theory of the case, then we're only doing what's necessary. Here's a question I ask when I decide whether I'm going to cross-examine a witness. Can I ask the witness any question that furthers my theory of the case? Any question. Just a single one. If the answer is yes, then I cross-examine the witness. If the answer is no, I don't cross-examine the witness. You may also want to help the witness off the stand before your opponent thinks of more questions to ask or before the judge starts asking questions. Rules of examination. Leading questions only. Right? Through the trial, we primarily advance our theory of the case through cross-examination. Leading questions only. You're not going to ask open-ended questions. What time was it when you went to the store? What time was it when you entered the bank? No, you're not going to ask that. You're going to ask questions. You entered the bank at 2:15 in the afternoon. You made it to the store at 2:15 in the afternoon. So that's what you're going to do. Oh, give me a moment. There we go. Ask one new fact per question. And questions must follow logical progression to each specific goal. So again, take it piece by piece. Proceed methodically. Now we're going to move ahead a bit. And I want to focus on time. The measure of importance is time. The importance of a fact is going to be demonstrated by how much time you spend on it. And if one fact is more important than another, if one part of your theory of the case is more important than another, then the time you spend on those portions has to be proportional. Again, don't waste time establishing an unimportant fact. There are two things I want to end with. The one is there's a framework for analyzing evidentiary issues. And what you see on the screen, you've probably seen before. The most important thing I want you to remember is determine whether you want the evidence admitted. I think a lot of people hear evidence, or they know there's a piece of evidence in the case that is admissible, or they think it's going to come in, and so they just let it. But really think of whether you want to admit it. Think of how it affects your theory of the case, right? You don't have to admit evidence just because it's relevant and admissible. Invest as much time as necessary developing a sound theory of the case, because it will be the foundation and framework upon which your advocacy is constructed. Thank you.
Great. Thank you so much, Anthony, for your very comprehensive program and your expertise in this area. It was fantastic. You're going to have an opportunity to actually talk with Anthony live in just a couple of minutes after I give a few brief announcements in the live Q&A program that we're going to have right away. So just make sure, if you need materials and evaluation forms, they can be downloaded from this session page in the Files tab above the chat. Attendance certificates will be available after the Thanksgiving holiday. You can get more information about that in the FAQ tab. So now please click on the link below to join the live Q&A session with Anthony Matriciani. Thanks again. I'll see you there.